Most of my clients would prefer to be divorced yesterday. But since we don't have a time machine and we can't travel back to make that happen, we settle for getting them through the process as quickly and painlessly as possible. Hi, I'm Max Ruthenberg-Marshall, attorney and founder of Porchlight. Today we're going to be talking about how long it takes to get divorced in Georgia. There are a couple of factors that contribute to the length of the divorce. First is whether your state has a pre-filing separation requirement. Luckily, we don't have that requirement here in Georgia. So you don't have to be separated from your spouse for 6 months or a year or anything like that. You can be separated for 1 minute and go and file the divorce. Another statutory reason that can cause delay in divorce cases is what we call a cooling off period. Georgia does have one of these, but luckily it's fairly short. In Georgia, the cooling off period is 30 days. So when you file a case, the court can't grant your divorce until 30 days after that filing. We also have a residency requirement here in Georgia. You or your spouse have to be a resident of the state of Georgia to pursue your divorce case in Georgia. Well, for most people, this isn't a problem. They have been living in Georgia for a while and they can just go ahead and file. But if you've moved here recently, this could delay your case. You're required to have lived in Georgia for 6 months prior to filing your divorce case. So if you haven't met that residency requirement, you do need to wait to hit that 6-month mark. Otherwise, your divorce could be dismissed. Now that we've addressed the waiting periods, let's talk about some of the bigger factors that affect the timeline of your divorce. One of the biggest factors is whether or not your case is contested or uncontested. Contested cases are much more complex. There are several formal stages that they go through after the filing of the initial petition. And they can also depend on how busy the court's calendar is. So whether or not you need a temporary hearing or a final trial, if you're trying to get in on the court's calendar, but they're booked solid, that's going to cause delay in your case. Right now, unfortunately, many of the courts are still suffering from COVID-related backlogs. The courts were closed for a significant period of time. It took them a while to transition to virtual hearings, and not all matters were being addressed through virtual hearings. So there is a backlog of cases, and it's taking even longer than usual to get into court. But even under non-COVID circumstances, there can be things that cause the judge's calendar to be backlogged. For example, if the judge is hearing a 6-week murder trial, that's going to take priority over your divorce. And then there's still going to be all the other cases on the judge's docket that they have to schedule, and many of them may have been filed before your case and take priority over your case. In contrast, the timeline for an uncontested case is much more in your control. There is a negotiations period where you and your spouse try and work out all the terms of your divorce before you sign the papers and file it with the court. How long those negotiations take is really up to you and your spouse. Then once you file, you do face that 30-day waiting period or cooling off period, but the judge usually signs your divorce decree pretty close to that 30 days expiring. Another factor that can affect the timeline of your divorce is whether it's a fault or a no-fault divorce. Most people file for a no-fault divorce, citing that the marriage is irretrievably broken. This just means y'all don't want to be married anymore. But there are fault-based grounds that you can allege, the most common of which is adultery. And if you allege those fault-based grounds, you're going to have to go to trial and prove them in front of the court. Again, that goes back to potential backlogs on the court's calendar. It could take a while to get in and actually have that hearing. Another major factor is the complexity of the case. Not all divorces are the same. So for example, take a case of a couple that's only been married 2 years. They don't have any significant assets, no retirement or investment accounts. They don't own a home, they're renting an apartment, and they don't have any children together. There just aren't that many pieces of the puzzle to deal with there. So it's much easier to resolve the divorce and have them both move on with their separate lives. In contrast to that, let's say you have a couple that's been married 15 years, they have 3 kids, they own a home, they both have retirement accounts, they both have investment accounts, and one of them owns a marital business. That's an extremely complicated case. There are a lot of puzzle pieces there that have to be figured out. And just the logistics of making sure you have all the accurate information to create a settlement agreement can add time to your case. Of course, if you and your spouse are motivated, even if you have a complex divorce like that, you can get through it quickly, but it does require some organization and diligence. So how long are you looking at total? Well, for a contested case, It's possible that you're looking at 6 months to a year or more. In contrast to an uncontested case, again, depending on how long the negotiations with your spouse take, you're probably looking at 2 to 3 months. I know that answer is probably longer than you would like, but again, you can make it shorter if you go through the uncontested process rather than a contested process. If you need help with an uncontested divorce, give Porchlight a call. We're here to help you through the process.